proceed in this way. We're going to hear the argument in the first case, and then we will take some questions, hopefully from students, for 15 or 20 minutes. We'll take a short recess, and we'll come back and hear the argument in the second case. And our first case is State v. Ronald Alan Everett. Mr. Kelly?
May it please the court. At issue today are two solicitation convictions. One involving the defendant asking a fellow inmate, a man named Piat, to murder a witness in his upcoming trial named Moss. The second one involves the defendant asking another inmate again, Van Alstyne, to deliver a DVD to a motorcycle gang in the hope, according to the state, that the motorcycle gang would then kill Piat, who didn't cooperate with the first solicitation. I'm going to do these in reverse order and start with the solicitation involving Van Alstyne. I think there's two statutes we need to look at in analyzing this problem. The first is simply the solicitation statute, ORS 161.435, which basically tells us that it's a crime to command or solicit another person to commit a crime. This crime is completed whether or not the solicited person actually goes through with committing the crime. So simply going up to somebody and asking them, please would you go and commit this crime, that's the crime of solicitation right there. The second statute that gets involved is the aiding and abetting statute, ORS 161.155. That's the statute that says that you are liable for the conduct of another person if that conduct constitutes a crime, if, with the intent to promote or facilitate the commission of the crime, you aid or abet or agree or attempt to aid or abet that person in planning or committing the crime. That statute involves an actual committed crime. So you have that person who you are cooperating with goes through with committing the crime, and you, the defendant, are aiding and abetting in the commission of that crime.
Suppose there's no finally committed crime.
Then there is no aiding and abetting.
Okay.
There could be a solicitation, but there's no aiding and abetting. And so what we have is the state's theory on this crime is that the defendant asked Van Alstyne to deliver information to the motorcycle gang. The motorcycle gang would then commit the crime. By the state's thinking, Van Alstyne, he was asking Van Alstyne to be an accomplice in a crime, and so he was then asking Van Alstyne basically to commit a crime, to go and be an accomplice to a crime. There's two problems with the state's thinking, and it's also the thinking that the Court of Appeals accepted. The first problem is this is a DVD. This is a DVD with an interview by prison officials, an interview that they had with Mr. Piat, where Mr. Piat basically talks about the solicitation involving Moss. So it's not a request to anyone to do anything. It's a DVD showing an interview.
Well, the state's, as I understand the state's argument, though, it's that it's what's on that DVD that counts. What's on that DVD is evidence that a member of the outsider gang was ratting out the gang, or another member of the gang, and that if that DVD gets into the hands of the outsiders, they will take care of him.
That is the state's theory, Judge. Well, first to correct your facts, okay? It was not a member of, well, I won't correct your facts. Your facts are accurate. What's wrong with the theory, though, is the DVD is not requesting anyone to do anything. The statute speaks of soliciting or commanding somebody to go and commit a crime. We have in the...
he understood that this was far more than a hope on his part, because he understood what would happen if that information was conveyed.
According to the state's theory, this defendant absolutely had the hope that delivering this DVD would cause the outsiders to handle the situation and take some kind of measure against Mr. Piat to punish him basically for what he had done. That is the state's theory. That might have even been the hope of this defendant.
Was this just a fact question?
A fact question might be, what did this defendant intend? That would be a fact question. But it's not a fact question of whether a DVD, asking somebody to take a DVD to a third party is commanding or soliciting that the commission of a crime.
Why could the jury find that receipt of the DVD was like receipt of a note saying, please murder Piat because it's cooperated with the police?
Because it's not.
Okay.
In the legislative history, we actually have a consideration of putting in the word encourage and request, and that was not put into the statute. Encourage, this, you might say this was encouraging the commission of a crime. This was hoping it might happen. This is not saying, please hurt this person.
I'm not saying that there
kill
have
this
to be
person.
some magic words used for there to be a solicitation, or are you?
There's not magic words. Solicitation could happen with many kinds of words.
Non-verbal communication, for example, or...
I could imagine all kinds of scenarios where something other than the words, please kill this person, would be sufficient to create a crime. But this is none of those things. This is a DVD showing a person doing something that the Outsiders Club might or might not care to respond to, and who knows how they would respond to it. They might go to Piat and say, that was a nasty thing you did. They might go to Piat and say, good going. You got your prison term shortened. Who knows how they would respond? This is not, please kill Piat, please hurt Piat. This is giving information that this defendant, if we infer all the things the state might want to infer, this defendant wanted to have Mr. Piat punished in some fashion.
I don't understand why the reaction of the person solicited is the key. It makes it sound as though you're keen off the fact that you don't know what that person is going to do in response to whatever information or request you make to them. But you never know that for a solicitation case, do you? Except after the fact.
The reaction is not key because solicitation is completed whether or not the person agrees to go through with the request or not. My point is, this is not a request.
So if instead of the DVD it was $10,000 in Piat's name,
$10,000 in
and the name of the person who's to be killed.
I don't know enough about the criminal world to know whether that would constitute a request. Conceivably,
Well,
I compare.
if you have testimony that it's given with the intent,
If you have testimony that
the expectation of the community.
if you have testimony that this defendant had reason to know that the delivery of Piat's name with $10,000 would be created, would be taken as a request to have him murdered. Yes, but we don't have that. I mean, we have Mr. Piat himself saying that the outsiders don't like people who rat out other people. Well, okay. How is this a request? I mean, I could put on the front page of I could put an advertisement in the newspaper. Mr. Piat is a dirty dog. He ratted me out. I could put an advertisement in the newspaper saying that. Is that the crime of solicitation? Because maybe the outsiders are going to notice that advertisement. I don't think that's a request to commit a crime, and that's what solicitation is.
I thought the record also showed that there was evidence that the outsiders didn't appreciate people ratting them out, and that they took care of them, and by that we don't mean putting them in an old folks home.
There was such testimony. But this is not a request. This is akin to the advertisement. I'm putting Mr. Piat in a bad light. And I'm putting him in a bad light with people who might be very unhappy. We don't know what they'll do. It's not a request. The statute doesn't say if you communicate information that could cause someone to be harmed, and retaliation to that information. The statute speaks of you are soliciting or commanding somebody to commit a crime. That's the problem.
In this case, the person requested was not the outsiders. The person who the defendant was alleged to have made the request to was Van Alstyne, right?
And that's the second problem with the state's theory, because he's not charged with soliciting the outsiders. He's charged with soliciting Van Alstyne. And since Van Alstyne didn't go through with this crime, Van Alstyne, in fact, is not guilty of a crime. He is not an aider and abetter. He is not an aider and abetter. To be an aider and
He doesn't
abetter.
have to go through with it, though, when you said what?
Van Alstyne had to go through with it. I mean, the outsiders had to go through with it in order for Van Alstyne to be an aider and abetter.
But Van Alstyne doesn't have to be an aider and abetter, actually. He just has to be solicited to be an aider and abetter.
He has to be solicited to commit a crime.
And the crime would be...
There's no completed crime.
Help me, that I thought solicit or aiding and abetting is either you aid and abet or you agree or attempt to aid and abet. So why isn't it true, or why couldn't the state say that essentially defendant asked Van Alstyne to attempt to aid and abet a crime that never occurred? And if he said, I want you to take this gun so that they can kill Piat, and Van Alstyne did that, even though Van Alstyne didn't ultimately do it, he had agreed to attempt to aid and abet. Or at least that's a crime that defendant presumably might have asked Van Alstyne to commit.
And I think the answer is the first line of the aiding and abetting statute. A person is criminally liable for the conduct of another person constituting a crime. If some things happen, you are not, if you simply ask someone to commit a crime, that's solicitation. But to be an aider and abetter, somebody else has to go through with committing a crime, and you, the aider and abetter, have to be assisting them in some fashion. Van Alstyne is not an aider and abetter under these facts. Even if he had gone through with delivering the DVD, he could not be an aider and abetter, and not unless the outsiders actually committed a crime or attempted to commit a crime.
It could be an attempt situation, it doesn't have to be a completed crime, right? The outsider, if there was evidence, you would agree that if there was evidence that the outsiders attempted to...
That would do the job.
That
would do the job, absolutely. But the outsiders have to be actors for Van Alstyne to be an aider and abetter.
So you're saying aiding and abetting is not itself a crime?
It is not a crime. It is not a crime. So when we say that we are asking somebody to become an aider and abetter, we are not asking someone to commit a crime.
It's a theory of liability.
It is a theory of liability. And that's the second problem with the state's presentation.
So would you agree that if the outsiders had attempted to murder Pia, the request that Van Alstyne deliver the DVD would have been a solicitation?
I'm not sure of the answer. That would be a closer case, because in that situation, he would be culpable of, Van Alstyne would be culpable of the outsider's crime. And so what we would be having is, please do something that will make you culpable of a third party's crime. And I don't know whether that would be covered or not, but we don't have that, because we finally have no ultimate crime committed by the outsiders or by Van Alstyne. So we have a solicitation to go and become an aider and abetter to a crime that never got committed and no one has committed. So those are the problems with the state's first solicitation. The second, yes.
There's a comment in the commentary, I think, to a solicitation statute that says, if A solicits B to solicit C, then A is can be charged with solicitation.
Yes.
Is that the situation?
No. And here's why. If you say, if A solicits B to solicit C, and you have a resulting crime, I would agree with that. The question is, what is the crime? I would say that if A asks B to do C, ask C, that's a solicitation to commit a solicitation.
Right.
And that would be a crime. If I asked you to commit the crime of solicitation, I've committed a crime. It's all my own crime of solicitation, but that's not what was charged. If you look at the indictment, he's charged with having asked Van Alstyne to commit a murder. That's what's charged in the indictment. That's what we have to look at. What's in the commentary is, yes, there's a crime that results, but not the one charged here.
And a motion for acquittal, if there's proof of solicitation to solicit, a different crime is substituted as proof.
We can't switch crimes around when we have something in the indictment where we're trying what's in the indictment. If we don't like what's in the indictment, we charge another crime. Sometimes we charge more than one thing in an indictment.
And a motion for judgment of acquittal is the right way to get to that problem.
It would be a way to get to the problem here, which is that the thing in the indictment was not proven, yes. There's no facts out of which we can get a conviction on this indictment from the evidence presented.
I want you to go back to Justice Walter's question a bit, because I think I lost your train of thought here. I'm reading from the commentary which says, pursuant to this section, where A solicits B to commit a crime specified by A, or where A solicits B to solicit C to commit such a crime, A's act constitutes the crime of solicitation, whether or not B or C, as the case may be, actually commits or even attempts to commit the crime.
Yes, and I would agree with that.
Even if C doesn't attempt to commit the crime.
Yes,
Is that what happened here?
because that scenario describes soliciting someone to solicit a crime. And that second solicitation, we don't have to complete the crime to get the crime of solicitation.
So the point is not whether C commits or attempts to commit a crime. The question in your view is whether A actually asks them to commit a crime.
No. My point is, we have charged here that A asked B to murder somebody. What's described in the commentary is A asking B to ask C to commit a crime.
Right.
That is the crime of soliciting a solicitation. That's what the commentary describes. We don't have that charged here. The second matter involves State versus Cox principally, and just the whole thinking about what limits can a trial judge impose on cross-examination, and if full cross-examination is not allowed, is that a problem? That requires the striking of a witness's testimony, and ultimately, as the arguments have been framed, the question becomes, was this a collateral matter that my client was not allowed to cross-examine Piat concerning? And the thing he wasn't allowed to ask Piat was, have you killed anybody? And the state says, the Court of Appeals agrees, this was a collateral matter. The matter of had Piat ever killed anyone before was not finally material to the thing charged, to the evidence needed to create a conviction. We didn't need to allow this kind of exploration.
What's the standard of review that applies to that particular assignment?
The trial judge has discretion to make those kinds of decisions, and so it would be for an abuse of discretion. And the discretion was definitely abused if this was not a collateral matter. If it was a collateral matter, the judge was within his discretion in denying his right to cross-examine. So that's really the issue. Was this collateral or not? And the background, of course, requires us to just realize that all of the evidence on this subject came from Piat himself. We don't have the defendant testifying. We have Piat telling about how he was the enforcer for this motorcycle gang, and he enforced breaking of the rules, and breaking of the rules required him to hurt people and frequently kill them. He repeated again and again, yes, you could get killed for that, and you could get killed for that. I was the enforcer. And a person with that kind of reputation would be exactly the kind of person you would ask to go and commit a murder for you if I wanted someone to commit a murder, I wouldn't ask myself. I wouldn't ask people in this room, presumably. I would ask someone like Mr. Piatt, who perhaps had told me I'm a murderer, or who had a reputation as a murderer. That's the kind of person I would ask. So the question then becomes, is Piatt a murderer? Does he have the reputation of a murderer?
Does he have a reputation of a murderer, not whether he is or isn't?
Well, if he's a murderer, no one knows about it, it wouldn't matter. My thinking is if you are a murderer, you might have the reputation for being a murderer. But finally, it's the reputation that matters. But whether he is or not goes towards establishing whether he's going to have a reputation for one. Whether he is or not goes towards whether he might have told this defendant that I'm a murderer. When the defendant approaches him in this theoretical conversation and says, would you please murder Moss? One might imagine that Piatt would say, happy to do it, I've murdered lots of people. Or maybe he didn't say that. The point is, this is a topic that this defendant should have been allowed to explore. It's not a collateral matter. And finally, if the state didn't like that, the state could have given Mr. Piatt immunity. We don't have to strike his testimony. We could have the state come in and say, you know, we're willing to give Mr. Piatt immunity if he ends up talking about having murdered different people because we want his testimony preserved and we want the defendant to have his full right to cross-examine. And the state had that out and then they chose not to take it. And my time is up.
Time is up, Mr. Keller.
Thank you.
Mr. Zier.
May it please the court. Fortunately, the defendant selected two people who had consciences and did not go through with the solicitation. Now, I'll address the defendant's argument in the same way that he did. The second claim is purely sufficiency of the evidence claim. As to, did the state present enough evidence for any rational trier of fact to find the elements of crime beyond reasonable doubt? And this court's review is in light most favorable to the state, with all inferences drawn, permissible inferences drawn for the state. Under that standard, this is what the facts of the trial show. Defendant knew that Piatt had told police that defendant had solicited him to murder a deputy sheriff. Defendant knew that Piatt was a witness in the charge of attempting to murder the police deputy. Defendant learned and had possession of a DVD and the indictment that showed defendant ratting on him to the police, and the indictment showing Piatt was the state's witness. We also know from recorded jail conversations the defendant had talked to his father to get that DVD and that indictment to give to someone. The defendant knew that Piatt was a member of the Outsiders gang. He also knew that this gang was a particularly violent gang that prized loyalty. Defendant had repeated contacts with Van Alstyne in the jail. We can determine that through video surveillance, where they talked through the jail door to each other. We had Van Alstyne's testimony that defendant came to him initially saying he wished something would happen to Piatt. He told Van Alstyne that Piatt was a member of the Outsiders, that Piatt was ratting on him, and that he wanted somehow for Piatt not to show up for trial in this new case. Defendant didn't want Van Alstyne to write anything down, and that's significant because we know the reason he was caught in the first solicitation was he'd written repeated notes in trying to solicit the murder of Moss. So the one thing he was wised up to was not to leave written incriminating evidence in his own handwriting. The defendant also knew that Van Alstyne was about ready to get out of jail and would be able to do what he asked him to do. And he indicated that, asked Van Alstyne, or told him, if you're not going to get out of jail, I'll get somebody else to do it.
So what he asked him to do was to take the DVD to the Outsiders gang.
Correct. Told him where the clubhouse was. He said, go to anybody that's got an Outsiders patch on them, indicating they're a member of this gang, and they're going to take care of their own. They would handle
And
it.
it's they that's going to handle it, not Ben Alston.
That's correct. And we're not saying that he asked Van Alstyne to pull the trigger or kill. He's the middleman, the classic middleman of delivering the message, but go ahead.
So if your theory turns on aiding and abetting, whose criminal conduct is Van Alstyne aiding and abetting?
Well, he's aiding and abetting the Outsiders in committing the murder. He's also aiding and abetting.
How is he doing that?
Pardon?
How?
By giving them essentially the loaded gun. He knows.
Well, it's a loaded DVD.
Well, you go back to the evidence that we have. We have also evidence, and if I could just go through the rest of the evidence that we've got. You want to give them the DVD, defendant's done it. They'll take care of it. They'll handle it, and they'll make sure that Piat doesn't testify. He offered Van Alstyne a Mustang vehicle in payment for delivering this DVD. The evidence also was the street code amongst gangs is you don't rat people. The evidence also showed that cooperation with the police is one of the biggest violations of the Outsiders Code. And they will likely kill anybody who does that. We had testimony that handling it means, at minimum, violently beating somebody, but certainly includes killing them.
Well, these are all things he wanted to happen, and you're talking a lot about what he knew and what he believed. But in terms of his actions, it's just conveying information through an intermediary that would not be instrumental. Really, it's not an address of where the guy's hiding out or something like that. So how would Van Alstyne be furthering the commission there?
Because he's actually handing over the evidence that both defendant not only hopes for, but reasonably believes and expects will cause the Outsiders to kill him.
To provoke him.
Well, to kill him. And Van Alstyne knows that as well. And in fact, we obviously know that because Van Alstyne went to the police and said, I think Piat's life's in danger because defendant told me to deliver this, and I know if I deliver it, the Outsiders are gonna act. So
whose conduct constituting a crime? You said the Outsiders. You were about to mention another person.
Well,
whose conduct he was aiding and abetting.
he's aiding and abetting defendant's solicitation of the Outsiders.
Is he also aiding and abetting defendant's attempted murder of
Yes.
Piat?
Yes.
And that would be the crime, the conduct of the other person constituting a crime, whose behavior he's aiding and abetting.
Yeah. But what I think we have to look at is what position did defendant want Van Alstyne to be? And what he wanted him to be was an accomplice, a step in the line of getting the Outsiders to kill Piat. And he was a necessary step in that because he had to deliver the message. The DVD was the message. It didn't say in specific words, kill him, but they all knew that delivery of that would provoke the Outsiders to kill Piat.
So if I know that my friend is very jealous and I tell my friend, your girlfriend cheated on you, I'm an accessory to my friend's murder?
I guess how I would explain it, maybe a different step. Say it's this way. I know, and I'll use the initials, names with the initials of people. I know that Carl, with a C, his wife, that Carl's very jealous and has a violent temper and will he's said before, if I catch John, say, with my wife, I'm going to kill him. If defendant goes to his friend Bob, B, says, here's a picture, cell phone picture that's got a dated time and stamp of John and Carl's wife coming out of the motel room. I want you, Bob, to hand this picture over to Carl. And Carl will take care of it. Yes, Bob is, defendant is asking Bob to aid and abet, to solicit Carl to kill the ultimate victim. John.
Just take it with two people, A and B, and let's say that it's not a visit because it's a picture. If you just give the information, if A gives B the information, this event happened that I know is going to cause jealousy.
And there's evidence that you want and expect that to happen. It's like if defendant gave Van Alstyne a can of gasoline and told him to give it to the outsiders, and the outsiders were arsonists rather than murderers.
Just the information itself could be aiding and abetting
Yes.
if you intend the result.
Yeah, especially when that information is key to essentially prompting the crime or giving the one you want to commit the crime any reason to do that. And you're intending to have crimes result from your actions. And you can't immunize or insulate yourself from liability just by using an intermediary. Now, you can use an intermediary who doesn't know what he or she's doing, and they're not liable in that instance. But if you use somebody and ask them with their knowledge that what they're going to do, if they do it, is going to constitute, it's going to make them personally liable as an accomplice through an aiding and abetting situation or solicitation or an attempt situation. You're trying to make this middleman commit the crime of fostering and promoting the ultimate crime. And
Well, why isn't it, what's the response to Mr. Kelly's argument? This is just a solicitation to solicit.
well, I think if that's what it is, it clearly fits the crime here. You only have to solicit somebody to commit a felony or attempted felony. And it's absolutely, various justices read or referred to the commentary in the criminal court.
But does it fit the indictment? Does it fit the charge?
Well, the indictment said the conduct charged was Van Alstyne causing the death of Keogh. And our position is that causing the death is the conduct that's charged. And how Van Alstyne did that, would do that, is by becoming an accomplice or an aider and abettor, or a solicitor, asking and taking action that would render him personally criminally liable for the end result of getting the outsiders to kill Keogh.
So your answer is yes.
Yeah. Yes.
Is soliciting someone solicit someone different from soliciting someone to aid and abet a crime?
I suppose it is. And in the aiding and abetting statute, there are two different subsets. You can aid and or the accomplice liability. You can aid and abet, or you can solicit. And both of those render the principal or render the person liable as a principal. And if all defendants.
So which theory is the state relying on?
Well, I think it's either of those, whichever. I mean, the proof is sufficient to establish either of those.
You're saying the indictment is broad enough, it covers, what's charged in the indictment is unlawfully solicit Van Alstyne to unlawfully intentionally cause the death of Keogh.
Yes.
Through an intermediary.
Yes. However he does it.
However he does it.
And if defendant seems at this point to suggest some kind of supposed variance with the evidence or something, but I mean, it's motion for judgment on acquittal claim, sufficiency of the evidence. He never moved against the indictment. He never filed a motion on arrest of judgment or anything of that order. He never objected to the instructions that were given. So if that's what he's arguing, I don't think this is the appropriate avenue to get there.
You're saying that solicitation is also a theory of liability separate and apart from aiding and abetting?
Yes, under
But for that theory of liability a theory of liability is not the same as a crime. And so that's what's confusing me here, is to be charged with the crime of solicitation, you have to solicit another crime, not another theory of liability.
well, he was soliciting the aggravated murder or attempted aggravated murder of Peon from the outsiders as an aider and abetter.
He might have been soliciting the outsiders to do the actual crime.
Yeah, there's no question that.
But he was
that-
only soliciting Van Alstyne to do a theory of liability for the outsider's crime.
But it's a crime to solicit something. He asked Van Alstyne to solicit the outsiders.
That wasn't the charge. The charge
Well,
was
but-
you solicited Van Alstyne to murder.
Yeah, and part of the way he was causing the death, he didn't say murder, it was cause the death. He was asking Van Alstyne to take action that would end up resulting in causing Piot to be killed. The way he did it was, the way he wanted him to do it was by making Van Alstyne, I want you to become an accomplice or an aider or abettor to this crime.
Or a
But
solicitor.
asking him to do that, whether it's aid, abet, accomplice, solicitor, the way he did that made Van Alstyne personally liable. That's the crime he wanted Van Alstyne to commit. I want you, Van Alstyne, to take steps that makes you criminally liable just as much as the outsiders are. And
In sustaining the conviction, the Court of Appeals focused on Van Alstyne's understanding in part. Does the state agree with that? The focus in part is what Van Alstyne understood would happen if he conveyed the information, or
well, I think
are we
in
just
this.
looking at the defendant?
Well, we're mainly looking at defendant, but it's to link in Van Alstyne, he has to be acting with knowledge that his conduct is criminal. If he was completely innocent, he had no clue as to any of this. It was a sealed envelope. He didn't know any of the parties. Van Alstyne or defendant would still be soliciting the outsiders in that instance, but he'd just be using an innocent intermediary to pass the thing. Here, when you use somebody who knows that, knows the criminality of his conduct.
Well, how does that go to defendant's culpability? Because, so if there were evidence in this case that Van Alstyne didn't maybe really understand what was going on for some reason based on his capacity, there wouldn't be this crime.
Well, in that case, it would have been charged differently. It would have been just charged soliciting the outsiders. There would probably only be an attempted solicitation then, the way the facts played out, because the outsiders never got the message. But when Van Alstyne knows about it and the criminality of that makes him the part of the link. And as the commentary says, A can solicit B to solicit C to do something, and A is guilty of solicitation. And I don't see any shape or form of how these facts can be divorced from that situation. We've got A wanting B to kill C. Turning to the second.
Before you do
Sure.
that, I should probably remember this from Bruce. Was this a bench trial or a jury trial?
Jury trial.
So were there instructions to the jury that are consistent with the state's theory of how liability would attach to it?
Well, that's a good question. I believe so. As I said, defendant did not raise any challenge to the instructions here, so that hasn't been a focus of anybody's briefing here. And, certainly,
Would that be a problem if there's no challenge to the instructions?
would it be?
Defendant.
Well, I think so. If he's claiming there should have been a different, they should have been instructed differently to decide the case, he has to preserve a claim of error challenging that. All his claim of error is the evidence isn't sufficient to prove the crime. And we just look at the facts. Going to the second issue discussed about whether the question of whether he murdered anybody was properly precluded by the trial judge. I think the first question is, was that question relevant? And that's a legal determination. But without any connection to defendant, or nexus to him as to why that would make a difference, it's hard to see why that would be relevant. But even if it's marginally relevant, which then moves it into the abuse of discretion area, we've got what defendant is I think the point that he's missing is the key is defendant's belief, not what Piot actually was or did. And if he did something in the past and the defendant didn't know about it, that doesn't make any difference. The question is, did defendant believe that Piot was a killer? And that's what the evidence showed. Of course, the defendant asked this question and offered proof because it would have been improper to solicit an indication of constitutional rights in front of the jury. But our point is, whatever, had he been able to ask this question, neither answer would assist him. If Piot had said, sure, I've killed a dozen people in the past, well, that just bolsters the state's case. If Piot had said, no, I've never killed anybody, how does that affect defendant's intent at the time? We don't know if defendant knew that. If defendant mistakenly thought Piot was a murderer, whether Piot was or not doesn't affect whether he would ask him to do that. And there's also, even if defendant knew Piot never had killed anybody before, there's nothing to show that he wasn't asking him to commit his first murder. So the focus has to be on what the defendant's intent was in soliciting Piot. And the trial court only precluded that one question. Have you ever killed anybody before? And I'll note defendant indicated that if Piot said yes, he wanted to ask who, what, when, and where about all these other collateral things. The trial court precluded just one question, did not limit his cross-examination in any other way. Defendant was free to ask about whether what Piot had told him. Did Piot ever tell you he killed somebody or not? What defendant's reputation was. If he was a violent person. All those questions would have been permissible under the trial court's ruling here. This case, I think, is consistent with the Cardigo federal case that this court relied on in Cox, saying these other crimes were pretty collateral to the issue here. And in fact, it only goes to the credibility of Piot, not anything else. And as a side matter, that question we believe would be inadmissible under the evidence code 608-2 of a specific act of conduct that can't be inquired about. You can only ask about reputation evidence. And the defendant was free to do that. And in fact, it's interesting to note when the state tried to elicit Piatt's reputation in the community from Piatt, he gave an answer saying that he was well known in the muscle community, and defendant objected, saying it was speculative. Now, it's not clear whether that testimony got stricken or not, but he could have asked it himself on cross-examination and chose not to. If the court doesn't have any further questions, we'll rely on the brief.
It's not. Thank you very much.
Thank you.
Mr. Kelly, rebuttal.
May it please the court. During the discussion with the state's attorney, I think one of the issues that came up on what I'm calling our first issue is the soliciting, a solicitation really any different, or is it the same as soliciting the aiding and abetting? And I think the answer is that they're completely different. The first place where we notice the difference is the definition of solicitation. Solicitation is a person commits the crime of solicitation if with intent of causing another person to engage in specific conduct constituting a crime. Conduct constituting a crime. You have then committed the crime of solicitation. So you have to ask a person to commit a crime, not to simply become an aider and abetter, not to simply become a person who will be culpable for a crime that's principally committed by somebody else. So that's one difference. The other difference, I think, is just this.
You have to solicit them to engage in conduct.
Conduct constituting a crime. So that means a crime. Conduct constituting a crime is a crime, not conduct that makes you liable for a crime.
The conduct constituting a crime aiding and abetting a crime is a crime. I mean, that is the crime.
Aiding and abetting makes you culpable for the crime.
Right.
But it's not a crime.
But soliciting is.
Soliciting is. So that's one difference.
But that's the point that the state is making, is that what this soliciting Van Alstyne to solicit the outsiders is soliciting to solicit, and soliciting is itself a crime. It's not just an aiding and abetting, it is a crime.
Yes. If he had been charged with soliciting Van Alstyne to solicit the outsiders, that indictment was proven. But or if he'd been charged with an attempt to solicit the outsiders, that would have been proven.
Why isn't the indictment broad enough to encompass soliciting to solicit?
Because the indictment doesn't say that. It says soliciting David Van Alstyne to engage in conduct specifically unlawfully and intentionally causing the death of Barry Piatt. He's soliciting Van Alstyne to murder Piatt. That's what's charged. And then under the evidence, it turns out that really it's an accomplice theory.
And this is what I'm not quite clear on. Why doesn't the word cause, isn't that broad enough to include solicit as opposed to actually committing the murder? In other words, they solicited him to cause his death by soliciting his death, as opposed to by committing his death. At least cause might be broad enough to include that theory, maybe not. Take it from your point, maybe not.
Well, I think not.
Yeah, exactly.
Here's the other point I wanted to make.
But why not? Why not? I mean, without the solicitation, the murder wouldn't happen, assuming that it ever...
And I think I can answer that. It's not as simple as under the aiding and abetting statute. First of all, it requires that a crime be committed. You cannot be an aider and abetter unless the murder is completed. One of the ways you can aid and abet is to solicit. Okay, that the Court of Appeals relied on 2B. There's also 2A, which I've got at the bottom of my page 18. And when you solicit or command a person to commit a crime, and then they commit the crime, you are an aider and abettor. But that requires the completion of the crime. The solicitation statute, a different statute, that applies whether the criminal conduct is committed or not. And of course, it ends up a very different crime. In fact, one's an A felony versus a B felony kind of difference. So the difference matters. The legislature basically said if you are soliciting someone to commit a crime and the crime is committed, you are an aider and abettor. If you solicit and it's not committed, you are soliciting.
And this is maybe a little reflexive, it's a theory maybe a little reflexive. Why couldn't the crime that Van Alstyne allegedly aids and abets be the attempted murder of Peacock? That is, by soliciting, or by agreeing to solicit the outsider, to go to the outsiders, he aids and abets defendant's attempted murder of Peacock. And that there would be conduct constituting the crime in that instance being attempted murder. I mean, that may not fit in the indictment, that may not fit how it's been argued, and it may not fit in the law, but... To me, that would be an alternative way to consider wording the indictment, given these facts. I mean, to me, the facts prove soliciting a solicitation at best. Okay, and I still have problems with the content of the DVD and taking that as a request to commit a crime. But even if you get over that, it's soliciting a solicitation. That's how this needed to be charged. Or an attempted solicitation. There's more than one way this could have been written up, but the way they wrote it up is the wrong way. And what they wanted was the highest level of charge possible. They wanted that, I think it's an A felony. And they get an A felony if he's soliciting a murder. But he's not. So that's the big problem there. On the second argument, I would just like the court to picture the kind of cross-examination that I think needed to happen here. The defense would have been allowed to ask Piat, what is your reputation? And I think the answer, because Piat, I think, came across as a braggart, he would have said, everybody knows I go around killing people left and right whenever they break the rules. I'm an enforcer.
That's not the question that you asked and that was objected to, was it?
Correct. And so we could have asked that question.
Could have.
But would that question have helped the defense? The answer, the expected answer would have been, I'm a big guy who murders people regularly. That's my reputation. That's my reputation. I'm a big enforcer. And he clearly tried to give that impression. And a question might have been, what did you tell defendant? Well, I told defendant, I have a reputation as a big murderer. Everyone knows I'm a big murderer. The question you then want to ask, having gotten that information, which is really hurtful to the defense's case, I think that this idea that he has a reputation as a big murderer does not help the defense. The question you will then want to ask is, well, are you a murderer? And if the answer is no, then we can then say, well, okay, so you're coming in here telling us you have this big reputation as a big murderer, and now you're telling us you're not a murderer. What's up? That kind of cross-examination is the cross-examination the defendant was not allowed to have. And the key to that cross-examination was, so are you really a murderer? Are you really a murderer? And if he says, well, yeah, then, okay, who have you murdered? When, where, how? Tell me about this. That kind of examination might have gone a long way in attacking what this man was really trying to establish as his reputation. He had already established in his testimony, in his direct testimony, I'm this enforcer guy and I hurt people when they break rules. We didn't need to hear more about that, but we needed to be able to examine that whole thinking, and that's what was denied the defense, and that's finally the problem, and that's why this is not collateral. My time is about up. Thank you.